Dear listeners, welcome to Knowledge Session by TMSL. In this session, we are going to discuss the principles laid down by the Delhi High Court in case of Brand Equity Treaties Limited and three other petitioners. Yes, the decision held by the Delhi High Court to some extent has been diluted by the 16th May 2020 notification. But here we are discussing the principles laid down by this decision, which could have an impact on future of jurisprudence under the GST regime. Businesses can now relook to claim lost credit if any of these principles apply. The first principle that the Delhi High Court discussed was whether a vested and accrued right can be restricted by a subordinate legislation, to which the Delhi High Court held that a subordinate legislation did not have the rationale enough to restrict an accrued and vested right under law, which means the input tax credit which vested as a property to the assessee under the erstwhile indirect tax laws cannot be restricted by mere CGST rules. The second principle was on the fact that whether the term technical difficulties could only include challenges of GST and portal, to which the Delhi High Court held that the term should be widely interpreted to also include difficulties faced by the taxpayer due to follies of the respondent and should not be limited to those of GST and portal only. The third principle that was held was considering the above, what is the final timeline by which a taxpayer who has not been able to claim credit can now file this GST Tran 1, to which the Delhi High Court invoked Limitations Act 1963 and held 3 years would be a reasonable timeline to allow all those taxpayers who are unable to file Tran 1 and carry forward their credit to claim credit under the GST regime, which means now the revised timeline as per the Delhi High Court would stand at 30th June 2020. Lastly, the Delhi High Court also stated that this would not only apply to petitioner of this case, but also to all those assessees who have been aggrieved by the decision or aggrieved by any of the similar facts and unable to transition their lost credit. The principle with respect to Substantiative Right and Limitations Act has been diluted to some extent by notification issued on 16th May. Nonetheless, the other principles stay as is. We could discuss more in depth on how to avail benefit of this decision for your business. Do reach out to us on the contacts mentioned in the screen. Thank you.